Hi everyone, I'm Zi Han. Today I'll be talking about the Personal Data Protection Act 2010 on the legal developments, impact, and its pitfall. So the Personal Data Protection Act 2010 came into force on the 15th of November 2013. And the purpose of the PDPA is to safeguard personal data by requiring the data users to comply with certain obligations and conferring certain rights to the data subject in relation to their personal data. The PDPA applies to those who processes or who has control over or authorizes the processing of personal data in commercial transactions. They are known as the data user. And the Personal Data Protection Act, however, does not apply to federal and state government. Personal data that's processed outside of Malaysia and also further intended for not processing in the Malaysia and those that's within the family. Who must register with the commissioner? The classes of data users who have to be registered with the commissioner are data users that's in the sectors of communications, banking and finance, insurance, health, tourism and hospitalities, transportation, direct selling, services, real estate, utilities, pawnbroker, money lenders, and also education. And law firm is one of the sector of services that needs to be registered with the commissioner because it falls under the services sector. The certificate of registration must be renewed no later than 90 days before the date of expiry of the certificate. And the failure to register by the relevant sector will give rise to sanctions. There is a fine that is not exceeding 500K or an imprisonment for a term not exceeding 3 years or both. So now I will talk about the personal data. The definition of personal data in the PDPA Act is that those data must be information in respect of commercial transactions that can identify a person. Commercial transaction is defined as transactions of a commercial nature and include any matter relating to the supply or exchange of goods or services, agency, investment, financing, banking, and insurance. So only those personal data that can identify a person from that information is protected within the PDPA. For example, IC number, telephone number, home address, email address, date of birth, and also passport number. These personal data also include sensitive data such as race, religion, physical or mental health, political opinions, and offense records. There are three key parties to note here under the PDPA that I'll be used a lot in this sharing session. So the first party will be the data user. The data user is the person who either alone or jointly processes any personal data or has control over or authorizes the processing of any personal data. And data processor is the one who processes the personal data on behalf of the data user. However, they are not bound by the PDPA 2010. And also we have the data subject, the individual who is the subject of the personal data, such as a client, customers, patients, employees, and students. The obligations of data user under the PDPA is to comply with the 7 principles of personal data protection. And there are any data user who failed to comply with these 7 principles, they will be liable to pay a fine of up to 300K or imprisonment of up to 2 years or both. The first principle is the general principle. This principle prohibits the data user from processing personal data without the consent of the data subject. However, there are limited exceptions where consent is not required, such as for the performance of a contract in which the data subject is a party, for the administration of justice, to enter into a contract at the data subject's request, protecting the vital interests of the data subject and compliance with any legal obligations. However, this limited exceptions is not easy to satisfy, and the burden of proof is on the data user to satisfy that the data fall under one of the exceptions. The personal data cannot be processed Unless it is for a lawful purpose directly related to the data user's activity, the use of the data must be necessary or directly related to the purpose consented by the data subject, and it must be adequate and not excessive in relation to that purpose. The second principle is the notice and choice principle, where this principle requires the data user to inform the data subject of various matters in relation to the processing of his or her personal data. The data subject must be informed in writing, that is in both English and Malay language. Even though if the data subject is a foreigner, they must be told in both languages. And the personal data protection notice must contain information such as identifying the category of third parties to whom the personal data may be disclosed and the purposes of processing, and then the data subject's right to request access and correction of the personal data, and many more. This notice will have to be issued as soon as is practicable. That is when the data user first requests for the personal data from the data subject, when the data user first collects the personal data from the data subject, or before the data user uses it for a purpose other than the original purpose or disclose it to a third party. The consent obtained must be recorded and properly kept by the data users. The third principle here is the disclosure principle. So the question here is that to whom can the personal data be disclosed by the data user? Under this principle, the data user can only disclose the personal data for purposes that's already disclosed to the data subject in the written notice, the directly related purpose, and the class of third party that's already disclosed in the written notice. Processing of personal data for any other purposes, the data user must obtain additional consent to process the data for that other purposes, unless limited exceptions apply, such as where the disclosure is necessary for crime prevention, law or court order, or the data user reasonably believe he had the right to disclose or would have consent, or it is in the public interest. Again, the burden of proof is still on the data user to prove that it falls under one of the exceptions. The fourth principle is the security principle, which requires the data user to take practical steps to protect the personal data from loss, misuse, modification, unauthorized or accidental access, or disclosure, alteration, or destruction during its processing. In considering what type of security to adopt to protect the personal data, the Act requires that the data user to consider several factors, such as the nature of the personal data and the resulting harm, the place and location of the storage, the personnel with access, and the measures to ensure secure transfer of personal data. With regards to this principle, the Commission has issued a minimum standard expected from the data user to comply with this principle for both electronically and non-electronically processed data. For example, in relation to personnel with access, the receptionist should not have the same level of access to data compared to those in the higher management. And also, there should be limitation of access to only people that's needed to know of the personal data. And also, such as if there is a collection of sensitive data, such as credit card details, then the data user should take more steps to protect the data. The fifth principle here is the retention principle, which requires the personal data to not keep longer than is necessary to fulfill the purpose, and requires the data user to destroy or permanently delete if no longer required for the purpose for which it was to be processed. However, the Act was silent on how long the data can be kept. To comply with this principle, then the data user can look at other areas of law, such as which may have specified the minimum data retention periods. For example, under certain tax law, they did specify the maximum number of retention. And then same as the security principle, Commissioner has also issued a retention standard that is expected from the data user. The sixth principle is the data integrity principle, which requires the data user to take reasonable steps to ensure that the personal data is accurate, complete, not misleading, and kept up to date by having regard to the purpose, including any directly related purpose for which the personal data was collected and further processed. For example, the data user should inform the data subject about updating their personal data on their website or in the return notice, and also to update the personal data upon request by the data subject. The last principle here is the access principle, which the data subject has the right to access to their personal data kept by the data user, the right to correct the personal data if it is incorrect, inaccurate, misleading, or out of date, the right to withdraw consent for a particular purpose, and the right to prevent processing for purposes of direct marketing, unless its compliance to such request is refused under the Act. This means that the data subject have the right to a law firm or to any sector to request for a copy of their data, or to say that they want to withdraw their consent for the data user to process the data for a particular purpose. So these are the 7 principles which the data user have to comply under the PDPA. As I've mentioned just now, there are minimum standards that's issued by the Commissioner, which is called the Personal Data Protection Standard 2015 in relation to these 3 principles, the security, retention, and data integrity principles. For offenses that's committed by the body corporate, so if a body corporate, a company, commits an offense under this Act, then any person who at the time of the commission was a director, a CEO, a COO, manager, or secretary, or was purporting to act in any such capacity, or was in any manner or to any extent responsible for the management of the affairs of the body corporate, or was assisting in such management, they may be charged jointly or severally in the same proceedings. And in any event, if the body corporate is found to have committed the offense, then they shall be deemed to have committed that offense, unless, having regards to his functions in that capacity and to all the circumstances, he or she is able to prove that the offense was committed without his knowledge or consent, and that he had taken all reasonable precautions and exercised due diligence to prevent the commission of the offense. Talk about the common issues and pitfalls of the PDPA 2010. In relation to the consent principle, as I've mentioned just now, the general principle requires consent to be recorded and maintained properly by the data user. However, the burden of proof is on the data user to prove consent. This means that if written consent is obtained by verbally only, such as via phone calls or at meetings or any talks that's organized by the data user, or if the consent was earlier given is unclear or difficult to document and maintain, then the data user must obtain separately a written consent from the data subject. And also if the consent was obtained via social media, WhatsApp, or SMS, etc. On excessive collection of personal data, the principle requires the personal data is collected only necessary or related to the purposes for which it is collected. Means that the data user cannot collect any unnecessary personal data from the data subject. So if the data is not necessary or mandatory to be provided, then it should be clearly indicated as being optional. Otherwise, the data user will be at risk of being in breach of this principle for collecting excessive personal data. And the third point is on the PDP personal data protection notice, which the Act requires that the personal data protection notice to be issued as soon as practicable. There is when the data subject is first asked for his personal data by the data user, and also when the data user first collects the personal data, and in any other case before the data user uses the personal data. So the data user must expressly and clearly identify the category of third parties to whom the personal data may be disclosed, and any third party which was not included earlier must be expressly included in the notice. So any disclosure to anyone or for any particular purpose must be written down in the written notice and must obtain consent from the data subject. The fourth point is on the disclosure, where the personal data is disclosed to a third party. Record must be kept and maintained of the list of all the third parties to whom the personal data had been so disclosed, and the list must be maintained and periodically updated. On the retention of personal data, as I've mentioned just now, the Act was silent on the number of years for retention of personal data. But according to the minimum standard, the data users will have to comply with the retention policy and also the retention period for hard and soft copies. So the data user will have to refer to the relevant legislation to comply with this principle. On the sixth point is on the security principle, where the minimum standard issued by the commissioner requires the data user to keep physical copies of personal data in locked cabinets, and the data user must have a security policy security standard issued by the commissioner. In relation to those personal data that's disclosed to a third party acting as a data processor, data user must ensure that they obtain warranties regarding the sufficiency of their technical and organizational security measures under the security principle. And also data user must ensure that they enter into privacy, confidentiality, and data security agreements to whom the personal data is disclosed. For example, service providers, contractors, etc. On the current news about the Personal Data Protection Act, in 2017, the biggest number of offenses had mainly related to non-compliance with the general principle and also the disclosure principle. And there are 187 complaints were made to the commissioner in 2017 and had increased to 630 in 2018 and January 2019. In 2018, the largest number of complaints concerned the banking and financial sector, followed by the communication sector. Other sectors such as real estate and services sectors also received a number of complaints. Lastly, I will share some of the European Union case studies relating to the general data protection regulation applied in EU countries. In this case, the commissioner had received complaints from the public that the marketing text messages were sent to them by Restaurant X. Restaurant X was unable to prove consent. Some of the telephone numbers used to make reservations were added to the marketing text messaging field instead of the reservation field on its computer system. Restaurant X at that time was already the subject of several previous complaints in 2007 about marketing text messages. Unfortunately, one of the individuals concerned continued to receive marketing text messages after previous complaints. His numbers was not removed from the marketing database. The commissioner finds that the Restaurant X was in breach of the General Data Protection Regulation, and the restaurant was prosecuted for the 2007 breaches, as these were their first offenses. Was not prosecuted for the 2007 because they were their first offenses, but in 2008 the complaints were repeat offenses, and so the commissioner charged, convicted, and fined the Restaurant X for a total of 3,250 euros. In the Canada case, the complainant had made a claim for theft of jewelry and money to his insurance company, who referred him to an adjuster for processing. The adjuster required him to sign a personal information consent form as a condition of the service. The complainant complained about the information requested. So the question here is whether the adjuster requiring information such as claims and credit history, financial information, medical information, driver's record, employment information, and witness statements is excessive. The Privacy Commissioner finds that this information is not relevant to the claim and is excessive. So the Commissioner had ordered for the adjuster to redraft the language to comply with the Act. So the takeaway point from this case is that data user must not ask for more than you need. That is ask for more personal data from the data subject more than what is necessary to process the personal data for that purpose. The third case is where the complainant had borrowed money from a finance company and then had defaulted on the payments. He received letter from the debt collection agency assigned by the finance company where a copy of her identity card was pasted on the envelope. He then made a complaint that the debt collection agency disclosed her personal details to others by putting copy of her identification on the envelope. The commissioner found that the finance company had breached the legal requirement because it passed a copy of the identification card to the agency without the complainant's consent. Although the use of a debtor's personal data for purposes of recovering payments is a directly related purposes, but the finance company should confine the disclosure to data that is sufficient to fulfill that purpose. For example, the finance company should give the debt collection agency, such as the debtor's name, ID number, address would have sufficed to identify the debtor. There is no need to pass a copy of the identification card to the debt collection agency. The next case is where the data subject has provided his credit card details and email address to X for transaction in 2006. But in 2007 and 2008, the complainant had received emails from X regarding a cancellation of a concert for which he had not purchased a ticket. He also received subsequent emails from X that earlier email was sent in error and had asked data subject to ignore or delete such an email if he had not purchased the tickets. The question here is whether X should have retained the data subject's data for such amount of time. The commissioner findings that X had retained the personal data for 16 months. The commissioner considered 12 months is more appropriate. So the takeaway point here is that if there is no activity on a customer's account during that time, all details should be deleted. Also, in relation to credit card details, as it is sensitive data, it is more appropriate for the customers to opt in to have their credit card details retained rather than requiring the customer to uncheck a box when he purchased a ticket. The last case here is on the UK Cathay Pacific case. In March 2020, the Information Commissioner fined Cathay Pacific Airways Limited £500,000 for failing to protect the security of customers' personal data from 2014 to 2018. The Cathay Pacific's computer systems lack appropriate security measures. The attack was originated from the IT service provider's server, and there are more than 9 million data subjects affected, where the data subjects' information such as their name, nationality, state of birth, contact details were all disclosed to the public, and there are more than 12,000 complaints received worldwide. The commissioner finds that the database backups was not encrypted, the internet-facing server was accessible due to a known and publicized vulnerability, and many other IT server operating system antivirus-related issues. Certain accounts was given inappropriate privileges and the retention period was too long. Considering the EU cases that I've discussed just now, so the question here is whether the Malaysia PDPA should follow the European trend of a more stringent requirements and more investigation going forward. In fact, the PDPA is actually intertwined with other areas of law such as tax, employment, and competition law, and not just data compliance issue. So there are more work to be done. As such, the road to compliance of the PDPA is an ongoing process. For example, the methods of data collection and the types of data collected and processed may have changed over time due to technology and other developments. And the personal data collection practices, notice, contracts, etc. also need to be updated and reviewed from time to time. Okay, thank you.
Okay, so any question to Zi Han? You also may post your question in chat box if you have any. Okay, if there is no question, then we shall end our sharing session here. Thanks a lot, Zihan.
And